All right, welcome back, everyone, and thanks for joining us today. In the first part, Craig helped us think differently about intellectual property and how valuable IP is often hiding in plain sight within our organizations. For this second segment, Craig is going to zoom in specifically on patent rights, both domestic and foreign, and walk us through what prosecution actually looks like, along with key considerations around enforcement. Craig will connect strategy with real-world execution, how patents are secured, how they're protected across borders, and what to think about when it comes to defending your innovations. So with that, I'll turn it back over to Craig for part two.
Thank you, Ravi. Welcome for those that are joining. I'm Craig Miles. I'm the owner and the managing attorney at the Sierra Miles PC. We're a Fort Collins law firm. We're located in our brick and mortar building about maybe a mile or two from Innisphere. In my background, because we're going to talk about patents today, I've filed over 1,000 U.S. patent applications and prosecuted probably 2/3 or 3/4 of that number. And so I have a vast amount of experience going back 25 years in this. And, I can answer your questions after the end of the presentation, and we can take those up, and I'm pretty sure I can give you some advice on that. I'm going to now move. We talked in the first part of this presentation about information, ownership of information, disclosure of information to others, creating trade secrets, creating trademarks and trade dress, creating copyrights. And now we're going to talk about creating patent rights. And before I go into Rule 1 on slide 18, I'm going to just take a moment to talk about the disclosure of patentable ideas with others. Okay, I think that one of the things that occurs is that people are told that in the US we have a 1-year grace period. In other words, if you disclose the invention, no concern, because you have 1-year grace period and you can still file your patent application. That is true. It's not really a grace period. On the one hand, I mean, if you disclose the information to others, and because we're now in a first to file modality and not in a first to invent modality as we were, the person could run off and file their own patent application before you file yours. So it's a problem for you because to overcome that first filing, you'd have to file with the PTO, their forms, and to challenge that first filing. It is an expensive event and it takes some time and energy. And at the end of the day, I will tell you that most people that run off and kind of misappropriate the ideas of others tend to change them a little bit to make them tailored to themselves, and they will probably be successful. So yes, we have the 1-year grace period in the States, subject to other people competing with you for the first filing. Also, and importantly, I think that most people aren't aware that we are one of the very few countries that have a 1-year grace period. There are other countries that have a little bit of a grace period, Japan, South Africa, Canada in some circumstances. But in most countries, there is no grace period. And if you disclose place your information into the public domain, whether it's an offer for sale, journal article, website, basically place it into the public domain in any form, you won't be able to obtain any foreign patent rights at that point. So I think that's a very important issue. And a lot of people make that mistake. So in my experience, it's not unusual to have 4 or 5 people every year say they want to go into foreign countries and realize that they can't go into foreign countries because of their own disclosure. Okay. And then people will often be told, well, do it in a confidential setting. In other words, get an NDA between yourself and others. And then you can disclose the information and not worry about the disclosure period or having public disclosure. I'd like to raise 2 points on that. First, it is kind of interesting. There is a case where a person had a non-disclosure agreement with their manufacturer of their product, and they had some prototyping done. And that prototypist then went ahead and prepared the prototype and then sent the prototype back to the inventor along with an invoice. And the interesting part was the court found that to be an offer for sale. And because the party waited more than a year from that offer for sale from the party that was the prototypist to the inventor, they said they could not obtain patent rights or file a patent application because it was barred by the 1-year bar. Similarly, and also interesting is that you offer to sell an invention within a confidential setting. That also will set off the 1-year bar on the offer for sale, because we don't have there's no secret sale doctrine in the United States. There is a secret sale doctrine in some foreign countries like Europe. But again, in that particular case, the party offered to sell the product in confidence to another party and then waited more than a year after the offer, and the court said, "Oh, you've exceeded the 1-year bar on the offer for sale, so you can't get a patent." Okay, so those are two significant things to consider when you're disclosing information to others. Okay, so let's look at let's go to slide 18 and look at the rules here. Okay, the rule 1, there are 2 separate parts to making an invention. The first part is conception. And the second part is a reduction to practice. And so you only have an invention that's made only when both of these parts have been completed. So let's talk about the conception portion first. Conception is the person's first mental impression of the invention in almost a completed form. It can't just be bits and pieces of the conception, but really what the law is looking for is a complete conception. Almost all of the component parts of the invention are complete in the mind's eye, and all you have to do is reduce it to practice. And so in the reduction to practice part, there's 2 ways to do the reduction to practice. The first part is an actual reduction to practice, and that consists of actually making a prototype that reduces all of the features of the invention that's in the mind's eye into a physical form. Okay. And so I think that people very often ask me, well, do I have to have a prototype of my invention? And the answer is no, you don't have to have an actual reduction to practice. You can do a constructive reduction to practice, meaning that if you make drawing sheets and actually describe the invention so that all of the inventive parts within the parts in the figures is described properly so that a person can meet the enablement standard. That standard being, can a person looking at the figures and reading the description make and use the invention? And I think that this is a huge concern. I think that very often when people disclose their inventions to me, they produce their invention disclosure, and that may be many, many pages long. And so there's usually about 100 pages worth of what other people are doing or what the prior art consists of. And then when it actually comes to the reduction to practice portion, there might be 1 sentence or maybe a paragraph about what the invention is. And so be cautious. If you really are going to make an invention and you're going to do a constructive reduction to practice, you really need to make sure that your description of the invention and the figures include all of the unique features of that invention, and that the description portion actually describes all those features in sufficient detail to make and use the invention when somebody reads it. Okay, so is somebody asking a question? Okay. I'm going to move on. So I think that the most important aspect of this, of the conception portion, is for the parties to identify who are the inventors. Okay, this is incredibly important because when you file a patent application, you actually have to name all the inventors. And if you don't name all the inventors properly, in other words, have your named inventorship done properly on the patent application, the patent can be invalid. Okay, so the the threshold question in determining inventorship is that who conceived of the invention? So a person who conceives of the invention is considered to be the inventor, and people that help reduce it to practice or do the reduction to practice with you are not considered to be inventors. And so it's very important not to include people that are not inventors in your inventive entity on your patent application. Because once you include people that are non-inventors, you may find that your patent is invalid. And secondly, long after the patent is been prosecuted and has issued a patent, and somebody goes to challenge your patent, all of those individuals will be deposed in the court proceeding or the litigation. And all of the non-inventors are going to be proven to be not inventors. And what will happen to the litigation at that point is the court will actually stop the litigation at that point and force you to actually change the inventive entity to the correct inventive entity, to only name the inventors, or to add inventors that were not named. Okay. The other aspect about inventorship is that you'll recall from my earlier part one of this presentation that every inventor in an invention, if there are multiple inventors, actually own 100% of the patent rights in that invention. And so by naming that individual or not naming the individual, if you don't name the individual, they're going to say that they were defrauded and not named as an inventor, and that you misappropriated their right to their invention. Secondly, if you name them as an inventor, but you don't assign those rights to a single entity like a limited liability company or your Inc., each individual will have the right to go and sell that patent right, sell or license the rights in it, and they don't need the consent of the other parties to do that. So as you determine inventorship, you need to have all of the inventors assign their rights to a common entity, and then have the patent attorney then write the invention for the entity and not for the individual inventors, although the individual inventors, of course, will be involved in that process. I think that in my experience, when you have a team effort, it's very hard to disentangle who are inventors and who are not inventors. And I have actually had the issue where, if we look at Rule 2, merely holding the title of department head or owner of the company does not make you an inventor. I've actually had the instance where I've had a party, an owner of a company, assert that they were an inventor, and then later on it was discovered that they never contributed or had the conception and never contributed to that mental impression, and they were not inventors. And I had to actually go back and actually remove them as inventors and actually restructure the inventive entity at that point. If you're a person that's acting under the direction or supervision of a person who's done the conception, you're not an inventor, okay? So merely holding title in a company doesn't create inventorship, and you should not be named as an inventor. The other Rule 3 that I've seen repeatedly is where a person is saying, well, I've contributed a lot of money to it, and I should be named as an inventor. And again, contributing money to a company or to an inventor does not create inventorship. Okay, and so I've had that come up too, and I've actually had people claim they're inventors because they've invested in companies, and I've had to actually remove them from inventors later. Okay, so those are important points to keep in mind. Remember that there is no invention without the reduction to practice. I think that we have many people that come and say, well, I have this raw idea. And this is akin to saying, well, I've invented an anti-gravity machine, and of course, it's a wonderful idea, but if it's not reduced to practice, it's not an invention, and you cannot file the patent application on it at that point, okay? So it has to be a reduction to practice. The second item is, if you do produce the prototype, make sure that the prototype actually does work. I mean, I've had instances where a person had a prototype, and it looked great. I mean, it actually did operate to some extent, but when it came to actually performing the function that it was intended for, it never could quite do it. And so make certain that if you have a prototype and you're actually drafting a patent application based on a prototype, the prototype is actually successful in testing, okay? So do that. Also in the constructive reduction to practice, gosh, I cannot tell you how many times I've received, like I say, an invention disclosure that includes just a handful of comments about what's inventive and doesn't really include any comments about what is inventive. And so I'd like to kind of take that into discussing a little bit about provisional patent applications. I'm sure many of you have been told, well, you can file a provisional application, and you have a year from the provisional filing to file the non-provisional patent application. The concern I've had with that is that I think that people have a very vast, very important misimpression about provisionals and what needs to be included. So there are actually two Supreme Court cases on provisional patent applications. And the first case involves a party who filed a patent application, and it consisted of about 100 and maybe more than 100 photographs of the invention, literally taking an impression of the invention from every possible side and disassembling it, showing the components, laying them out, and filing the provisional application with just a lot of images. Similarly, the same thing could occur where a person files just a lot of figures, okay? The Supreme Court said, well, that doesn't satisfy the enablement requirement because the enablement requirement requires a set of figures and a description, and the description has to be cross-referenced by reference number to the figures, okay? In the second Supreme Court case, it was just the opposite. The person produced a very long description of the invention, but didn't produce any figures with it. And the Supreme Court said that was a problem too, because to enable a party to make and use the invention, you need a set of figures, and you need a set and a description that's cross-referenced to the figures. So in each case where there was either figures missing or detailed description missing, the Supreme Court found they weren't competent applications. And in each case, the party lost all of their patent rights because they were claiming priority to their provisional patent application, okay? So I cannot tell you how many people come to me with, here, I've written this provisional patent application, and even just recently, where they filed their own provisional patent applications, and they do not include figures with them. And it's difficult because they've waited almost a full year to come to us with their pro se filed provisional patent application that includes a relatively modest description and asking us, oh, well, just go ahead and file this, no problem. You can just file this as a non-provisional and it won't cost me very much money. But the answer is that any good attorney is going to tell that party, no, we need to actually go back and produce the figures, produce some claims, and produce a full description of the invention to the extent that it meets the enablement requirement. And I think that this is also coupled with, I think, a lot of misinformation about, oh, you don't need any claims in a provisional patent application. And I think that this is a huge disservice in the sense that, claims really are what characterize the scope of the invention, the scope of the invention. And it's hard for me to understand how an attorney can write a great patent application if they haven't actually written the claims to actually identify what are the inventive features of the invention. And ultimately, what I find is that when I then go and write the claims, I'm putting in a lot of structural features that aren't originally in the pro se application. And then we're actually adding new matter to the application, and you may not get your priority date for those features. So I would suggest that in a provisional application, even though the law says you don't need claims, that they're essential to actually understanding what you're going to describe and what you're going to show in the figures. Moreover, litigators hate provisional patent applications. They're awful during litigation. The reason is that the defendant is always going to go back to the provisional because they're going to try to find fault with the provisional. And especially those provisionals that don't have claims in them, when those inventors are deposed, the very first question about that likely to be asked after the usual routine questions is, well, what did you invent? And I will tell you, I've been in those depositions and represented people in those depositions, and I will tell you the inventors really never know what they invented, okay? And once they start to stumble along, it is all downhill from there. What I would suggest to you is that if you have claims, and maybe you shorten the claim set, but still have claims in your provisional, that when you're asked that question, what did you invent? You can open the provisional patent application up to the claims section and simply say, well, you see, here are the claims, and this is what the attorney drafted in terms of what the invention is, and that's what I invented. And I think that kind of closes the deposition up at that point, at least to the point where you can't stumble along too far. The other example is about 30 years ago, I worked for a firm where the partner actually has his paralegals make the provisional patent applications. And in that case, he was actually filing a provisional patent application with one very poorly crafted figure. And I will tell you, in the instance, in this case, it had about 3 sentences worth of content. And then we went on and we filed the non-provisional application, which was entirely complete and in every way and was wonderful. The client went out and did a contract with a very large sporting group. And in that sporting group was going to pay the inventor $1 for every product unit that they sold. So years passed and millions of product units were sold and the client never received $1, okay? And so the partner that wrote that provisional patent application went ahead and sued. And during the litigation, the judge said, well, I want to see the provisional patent application. And I will tell you that, of course, the partner hemmed and hawed and delayed and delayed. And finally, the judge said, after about 3 or 4 months of this, that I'm going to dismiss the case if you don't give me a copy of the provisional application. So, of course, it was turned over to him, and the judge contemplated about a month or two and then got back and said, well, I'm going to, find in favor of the defendant. And the reason is because I can't tell what the invention is. And so when I look at the contract, I can't tell what the scope of the invention is with regard to the payment of the $1 on units. And so the client lost that case because of the very poorly drafted provisional patent application. So take away with provisional patent applications. They are not an invitation to simply do a poorly crafted job or to write a few sentences. But you really have to meet that enablement standard. And quite honestly, we would likely not file a provisional unless it was almost readily convertible to a non-provisional patent application. Otherwise, you should just wait until you have the invention sort of fully conceived and fully reduced to practice and take it up then, but just keep it non-disclosed to that point. There are good reasons to file provisional applications. They are very few in number. The first good reason is that if you have, say, for example, a chemical composition, you may want to maintain that chemical composition secret for as long as possible. And so in that case, we would file a fully enabled, ready to file as a non-provisional application with all the bells and whistles, and just hold it as a provisional for about a year, and then file the non-provisional, and then the publication of the non-provisional doesn't occur for up to 18 months, typically within a year, but it can be another 18 months. And honestly, they're protecting their trade secret rights for a long period of time. The second reason is that if you are in the pharmaceutical industry, you're probably looking at a production or development of that pharmaceutical, marketing and commercialization of that product for over many years. And the most lucrative return on investment for pharmaceuticals is going to be at the, right at the tail end of the patent right. So you're at the 20-year mark. Oh, and by the way, if you file a provisional, it doesn't start the term of your patent. And so from a provisional point of view, if I file the provisional application, then I file the non-provisional, you've held those rights for a 21-year period of time. And then we can try to sort out what we can do in terms of continuation applications to try and extend the patent right even a little bit further, okay, or continuation in part. So returning back to the inventorship, I want to talk about invention a little bit more. And this comes up in terms of artificial intelligence, okay? And so I've had the instance recently where people have brought me disclosures that are very clearly written by artificial intelligence. Chat or whatever the platform is created the description of the invention, okay? And they say, oh, there's a description and there's some claims that Chat wrote, and why don't you go ahead and file that as an application? The problem with that is that if you have if AI has been the conceiver of the features that make up the invention. In the United States and in many other major jurisdictions, only a natural person can actually be named as an inventor and move the patent application along. And in fact, AI-assisted invention may not be patentable. And under current US law, the application that's created by artificial intelligence, it may be dedicated to the public at that point, and you may not have any rights in that invention at all, okay? So if you're working with AI, human conception is a requirement. Very few countries, there are a few, but very few countries will allow you to name AI as a named inventor. So inventorship in the US and most countries is still based on human conception, not AI conception. So what do we do then? How do we protect ourselves in that respect? You have to look at AI as being a tool to help you. And I use AI, it's very helpful. It really is. You need to view it as a sophisticated tool, similar to a complex piece of lab equipment, okay? You need to actually use that tool to actually prompt it to give you bits and pieces. In other words, you conceive, and then you ask for information about that conception to help you define the parts of that invention a bit, describe what a valve is, describe what a flap is. Those things are fine, but you don't want to prompt the AI to say, well, conceive of a valve that does a particular item. Then you're falling into the problem with the significant contribution test at the USPTO, which is when the USPTO looks at AI-assisted patent applications, they use what's called the significant contribution test. The human contribution must be significant in the overall invention, okay? Simply recognizing a problem and putting general prompts or merely appreciating AI's output as an invention is generally not sufficient to qualify to meet the significant contribution test or to qualify as an inventor. So some examples of this, it gets very complex actually. Examples of sufficient human contribution. If you're designing, building, or training an AI system in view of a specific problem to elicit a particular solution, you probably are meeting that significant contribution test. Taking the AI's output, as I suggested, taking output about definitions, general features, help with language, taking an AI's output, but then you make substantial modifications or addition to create the mental impression. That is certainly going to be meeting the human contribution test. If you construct a highly specific prompt in view of a specific problem that a person of ordinary skill in the art would not have been able to formulate, thereby eliciting a particular non-obvious solution from the AI, probably does meet the significant contribution test. Okay? Again, the problem is we're playing with a gray area. And in my experience with people that provide me with AI generated content, the problem is that the AI is really leaning upon what's known in the prior art. And so I recently received a provisional application that was 100 pages long, created by AI. And again, when I read it, it was very obvious it was created by AI. And again, it talked about just at length, huge length, about literally everything known about particular component parts within the invention, but didn't actually bring the invention down to any form of practice that was beyond the prior art itself. And when I asked that client, I said, as an attorney, I'm faced with the problem where, really I need to write your claims to define what the invention is. And then you need to tell me what your initial mental impression was so that we can make sure that those claims are not AI generated, but are generated from your own mental impressions. And it wasn't surprising that I never heard from that individual again, So mindful that we're in a gray area. If the invention results purely from AI systems autonomous operation without significant human contribution, generally considered to be unpatentable and falls inside the public domain. So if you want all your efforts to fall into the public domain, AI is for you, okay? There are a few foreign countries that will allow you to name AI as an inventor. I'm not going to go into those because the problem is that if you meet the US standard, you're going to meet most of the standard in most of every other country in the world. There are slight differences in patent law between countries, but if you can identify the conception and you can define the reduction to practice, you're going to meet the standards of almost every country in the world. I mean, there are many countries that don't require an inventor, but they still require conception and some reduction to practice. So take it away with the AI that you don't want to be in the position where you're satisfying only the law in Pago Pago, but not in every other country in the world. Okay. Prosecution of a patent. Okay. I'm not sure how many of you have actually prosecuted patents. I've prosecuted hundreds and hundreds of patents. Okay. And so here is what you're trying to meet with your patent application. And the strategy that you use to write your claims is important because it will make it less likely you're going to get an invention or more likely to get an invention. And so let's take the strategy where you draft a very narrow claim set, okay? So a narrow claim set means that you're really talking about a claim that really is describing literally every feature exactly as it's shown in the figures, okay? There's nothing wrong with a narrow claim. If your strategy is that you want to hold a patent in hand so that you can show investors that you actually have an invention, I think that is a worthy of a narrow claim and a very good strategy. So sometimes holding a patent in hand is something that is important for investors to invest in your company and for you to move forward with manufacturing and making people feel secure that you're not just simply taking them down the path where you have this invention filed or this patent application filed, but you don't know where it's going. Okay? And people will ask you that question, do you think you can get a patent? So if you're getting those kinds of questions from investors, then maybe a narrow claiming strategy is for you. Okay. Now, the downside of the narrow patent claiming strategy is that very often, and this doesn't happen very often in my at practice because I tend to do the other way. I like to broadly claim inventions. But I do use this strategy. The downside to it is that you may receive what's called an ex parte quil action. Okay, so you file your patent application with the narrow claims, and it sits at the patent office for, God, 2 years before an examiner picks it up. And the examiner immediately says, "Oh my gosh, a very narrow claim. I can give you this claim, and I'm going to send you the ex parte quil action." So the ex parte quil action basically says, well, thank you, inventor, for submitting these very narrow claims. And that, by the way, the prosecution is closed now, and I'm not going to take any response from you, but I'm going to allow these claims, and you can then pay the issue fee and get a grant of patent. Okay. So the problem with that is that now you're stuck with this narrow set of claims and without any way to broaden them. Okay. The way you're going to end up broadening your claims is to file a continuation application prior to the issue of that patent application. And so what you're going to do then is get your ex parte quil action, immediately write the broad set of claims, and refile the application as a continuation application without adding any new material. And then paying the issue fee, get your grant of patent in hand, and then you're in this wonderful position, and I think it's kind of like the sweet spot, where you hold a grant of patent in hand and you have a patent pending for broad claims, so that on the one hand, you're inducing investors to come to you, and on the other hand, you can tell them that you have patent rights pending, which is quite a very good deterrent to people trying to copy, because they really don't know what the scope of your claims and your continuation are going to end up at. You may end up with a narrow patent and a broad patent. That is a sweet spot to be in. Okay. The other strategy option is to write the broad set of claims. And I'd say 80% of my work is filing the broad claims. Okay? There is some beauty to filing broad claims. First, in any time that you are asking for a broad invention, you're going to get a rejection in the first office action. Okay. So, I think that inventors get overly concerned about rejections because they call me and say, "Oh my God, we've been rejected. Does that mean I have to give up?" Well, no. I mean, what you want to do is flip that table over a little bit and say, "We love to have the rejection." Why do we love to have the rejection? Because it sets the bright line to what your potential patent breadth is, and it gives the attorney a bright line to work against with the examiner. In other words, examiners are tasked to interpret the claims as broadly as they can possibly interpret them. So if I claim, a part A that is coupled to part B, okay? So the coupled to language is a very broad recitation, okay? And so as an example, if I were, say, for example, I'm talking about the way a car is steering a wheel, okay? The examiner is going to say, well, the steering wheel is coupled to the wheel, okay? And all the parts in between the steering wheel and the wheel, all that steering mechanism and assemblage is within the scope of that claim. And so he's going to sweep in literally every automotive invention that has a steering wheel and a wheel. If I claim a steering wheel coupled to or configured to turn a wheel. Okay.
Craig,
Yeah.
sorry to interrupt. Are you still on the slide with Rule 1?
No, I'm way off from the slides now. I'm moving beyond the slides now and into the prosecution of applications once inventorship. The
Okay,
actual practice
thanks.
has been made. Sorry
Just-
about that. I should have clarified. When I created these slides, there's been so much change in the patent law since I created this slide deck that I felt like I had to go into AI, I had to go into the confidential setting, the disclosures, and now moving into the prosecution of the application, what it means to create patent breadth based upon your conception and reduction to practice. Okay. And so the beauty of filing the broad claim is that you will get rejected. and you have to just love that rejection. And the reason that you love the rejection is because it does set the bright line that I can go ahead and argue with the examiner or amend the claim slightly. Where I say coupled to,
Hey, Matt, it's Howard. So
Yeah.
how'd the conversation go?
are we good?
Mm-hmm.
Okay. So with regard to the coupled to language, I can actually change that to saying it's connected to or directly connected to. And by changing two words, I can overcome that rejection based upon the examiner's rejection based upon the broad patent right. So it is more expensive to prosecute broad claims because you're going to get a first office action. You're going to take up the rebuttal to that office action. We'll file the response. And the examiner is going to then have about 3 months to consider whether to give you the allowance based upon your rebuttal arguments and your claim amendments, or come back and reject again based upon the same prior art, or having done a new prior art search, new art at that point. And that process goes on reciprocally until the examiner really has basically can't bring up any more arguments or any
Right.
objection
Yeah.
arguments.
Yeah,
And
exactly.
then we'll then issue the allowance on the claims, and then you pay the issue fee. And before you get the patent issued, again, my strong suggestion to you is that if you really want to prevent
If you don't want
workarounds,
Yeah, I mean, yeah, and
if you really want to prevent workarounds, and you really want to prevent people from sort of wedging in another patent right, then what you want to do is file a continuation application. And I would say that if you have revenue generation on a product, you're going to want to file a continuation application for as long as you're generating revenue. People are becoming particularly inventive about how to work around patent rights. And quite frankly, I think that, as we all know, that if you're in the Amazon structure or the Amazon platform, anytime you generate revenue, you're going to generate a copycat. And so you're going to need to have the opportunity to redraft your claims. And as long as you have a pending application, you can actually amend those claims and resubsume the copycats at that point. Okay? Many years ago, I had the interesting experience where I filed a patent application for a client claiming an invention, broadly claimed it, got the patent right, and filed a continuation for that application. And that client produced very significant revenue. And so over the years, we filed 4 or 5 continuation applications, extending out the right to amend the claims for about 6 years. And then that inventor came to me with yet another invention, which seemed entirely different than the first invention. And I said, well, great, well, we'll prepare the patent application, we'll file it, and then we'll prosecute it, and I feel pretty confident you're going to get a patent out of it. And it was very interesting that this is 6 years after the initial application was filed, and the continuing application's still pending in that first original conception. And the examiner said, well, Mr. Miles, you know, I'm citing your other patent against you, the patent for that same client. Because, when I read the description, I can piece together bits and pieces, and I can actually build this second invention from the description in your first invention. And quite honestly, I was shocked and surprised. But what I said to the examiner says, well, examiner, if you're admitting that the invention exists in the first application and is continuing into the current pendency of that invention, then examiner, then what I'm going to do is I'm going to take your admission against your interest, and I'm going to file my claims in my continuation in the first invention. I did that, and the examiner granted me that patent based on the first description, and I simply just created the second one, but then filed continuation applications after that. So I think that the suggestion that you are finished with your conception and finished with your reduction to practice in one patent application probably is a misnomer. And I think that the only time you wouldn't file a continuing application is if, in fact, you weren't generating any revenue, because if you're not generating revenue, maybe there's no reason to maintain your patent rights at that point. Secondly, let's talk about continuations in part, okay? So say, for example, you have now this pendency in your patent application and you do improvements, okay? And you go to parties in confidential setting and you say, you know, we have this patent and we're trying to generate some revenue or some additional investors or want to offer these for sale. We're looking for marketing channels. And during that meeting, in that confidential setting, the party says, well, gosh, if only you had done these improvements, it'd be so much better, okay? Well, who do you think owns those improvements at that point? Okay. Now I go back to the rule 1. That's a conception. And the party that owns those improvements is going to be the party that actually had that mental impression during the meeting. And unless your non-disclosure agreement suggests that they have to assign all the improvements that are thought of based upon your confidential information, you will find that they will go and file a patent application for their improvements as a standalone patent application at that point. So on the other hand, you could take your improvements, and if you have a continuation application pending, and the improvements are, as the example that I gave, can be pieced together out of what's already in your disclosure, then that improvement can be covered and claimed. And we do that all the time very successfully. On the other hand, if you have an improvement that is very substantially different than your original conception, and you reduced it to practice, then I would suggest that you could file a continuation in part application in the US, but maybe it would be better to file a standalone patent application. And in that particular instance, then you'll be in the situation during the prosecution where the examiner will cite and apply against your claims your prior patent rights, or your prior patent applications. And that's fine, because I think if you set that bright line again, now you know what the scope of your improvements are in view of your own prior art, and you can get a separate patent with a brand new term on it, so you're not getting your term reduced, which would happen in a CIP, but you're going to get a brand new 20-year term. Okay. Secondly, in foreign patent rights, say I file into Europe or nearly every other country in the world, there is no continuation in part practice. Either your improvement can be differentiated from your prior patent rights, or they can't be, and you have to file a standalone application. And even if you take your continuation in part into the Patent Cooperation Treaty, which is the international application holding pattern, and then file into Europe, for example, you're still going to find that the only thing you're going to get out of the foreign country is the difference between your prior patent rights or prior patent applications and the claims that claim the improvements only. So I've used it both ways. I find the continuation in part in the States helpful. And sometimes I'll file a continuation in part, and sometimes I'll file a standalone application at the same time. And the purpose there is that very often when I do the continuation in part in the States, I get my same early priority date, and the examiner doesn't cite my own prior art against me. Where if I file the standalone application, the examiner is certainly going to cite all of my own prior applications against me, along with any other prior art that's relevant. So in that respect, in foreign countries, I would suggest that if you plan to get foreign rights, then I would file a standalone application in the States and carry it through separately into foreign countries. Okay. Ravi, we're about, what, 15 minutes to or 10 minutes to at this point?
We are about 9 minutes, I think.
Oh, okay. So let's open it up for questions, because that was a lot of information. And there weren't a lot of slides to take home with that. And I apologize for that, but no, I'll take up your questions. And we can take those up and see if we can fill in any gaps, okay?
And I will also be sending out the slides and a link to the video. But we got a question come through. What are your thoughts regarding business process innovations?
I think that, business or process patents, especially business process patents, you can file them. They are certainly subject matter for patent, okay? Here's what I would say is that they are very challenging to prosecute. And largely this is in part due to the Supreme Court case in Alice, where they restructured 35 USC section 101 about abstract ideas, okay? So, and I think it's a great question. I would say, yes, you should definitely try to have in any application file apparatus claims, method of making claims, so you get enforcement under 35 USC 271 F and G, which is separate from enforcement under 271A. But also, you would want to make certain that you have process claims that you believe represent a method of making certain items, like, say, for example, the process in a chemical process to go from ingredients to the resulting product. What are very, very difficult and very challenging to prosecute are computer software claims where there really isn't a computer software patent, and there really isn't a patent for just simply process, okay? So it's a little easier to understand in patent processing or computer processing, because if all you're doing is processing data, you're not going to get a patent for processing data. Under Section 101, the court is going to say, well, that's an abstract idea and not reduced down to a practical application. The things that in computers software that will achieve a patent are if the software actually drives a tangible device that is certainly subject matter for patent and overcomes the 101. Or if, for example, you put in the data, it's processed, and it transforms the result. So, for example, you put in images of a face and it transforms the image of the face into some other modified form of that face, and Jen gives you an image of that, where you're actually transforming data to a different result or a practical, tangible result. Those will also be subject matter for patent. If you have a patent process that you input, you process the program code and it restructures, for example, all of the icons on your display surface to put them in a different order, that has been patentable. So there you have a reduction to practical application. And so those are the examples there. The more difficult ones are, say, for example, you're processing, your business process is maybe a dating service, and you're processing people's data about what they find are their significant personality characteristics, and those are being matched against say job functions or organizational functions. Those are incredibly difficult to achieve a patent on. So what you're going to want to have in those applications in terms of business process, you're going to definitely want to have some tangible output where the user is actually interacting with those results to modify the results at that point. Okay. Does that answer the question, or am I missing the point there?
I think that answered it. I have 4 more questions listed.
Okay,
And I think we're probably going to go
wonderful.
a few minutes over time. So
We
if
can
you have to,
run as long as you want to, Ravi.
thanks.
As long as if people are interested, I'm interested. So let's go for it.
All right, I will continue on. And if people need to drop off, please feel free to do that too. So is an ML model trained on your data patentable?
Yes, if you are if you're training an AI model and that AI model actually does something different, the output of it can be reduced down to a tangible expression or reduction to a practical application, you should be able to obtain a patent for that. And I have that question come up quite frequently, where a person has a system that operates in an external environment, and there are monitors or sensors that operate within that environment, and the AI model is interpreting that environment and then changing the modalities on which the sensors work. That should be patentable, as an example. And I would say that even if you can come up with, if you design, build, or train an AI system to solve a specific problem and to elicit a particular reduction to practical application, you should be able to get that patented. Although I'll tell you, it will be very challenging to do that.
Thank you. So the next question is, can you elaborate on the use of AI to describe parts of an invention? Are you thinking to only describe parts that are not novel? Help us understand where is the line to not cross on use of AI.
That is a great question. It's a blurry line for sure. Okay. And what I would say is that if you have conceived of if you have a mental impression, okay, I'm going to give you the example. Let's do a simple mechanical example. Let's take the 3-bladed razor, okay? And so in my mental impression is a handle and this blade carrier, and I'm thinking about the 2-bladed razor that's known, and I'm thinking, well, gosh, it would be just so much better if I added the 3rd blade. So that's my mental impression. Okay, now how am I reducing it to practice? I'm going to use AI to assist me in that reduction to practice. So I'm not going to ask the AI to conceive of the 3rd blade. I'm going to ask the AI to, with particular prompts, what kind of blade material would I use to make a 3rd blade that's going to cut human hairs off from a face? And yes, it's going to give you what it can give you, which is going to be in the prior art, but it's going to be about general information about materials for blade making. And probably every blade known to man, probably give you swords and, may even hallucinate and give you, something out of science fiction where somebody's hands are scissor hands or something, So all I would say is that if it describes the materials to make the blade, and you might even prompt it to say, well, how sharp does the blade have to be? That'd probably be all right as well. But I wouldn't say to it generally, how do I make a three-bladed razor? That would definitely fall into the side that it would be AI generated conception. And I would simply lean on definitions of, and if you're writing your description, describe a blade, describe a handle, describe a two-bladed razor. I think all those are fair game, but I wouldn't say describe a three-bladed razor.
Thanks. All right. The next question is, if you have a team of US and European software engineers in your company make an invention, where do you file the patent? Where do you file it first? And does it matter if you're a US or European headquartered company?
Yeah, I think that is it's a multi-part question. Okay. Part one is you have a team of European and US. Are they software developers or just developers? I would be inclined to say that if you have a team made up of team members from different foreign countries, my suggestion would be that first, have this happen quite frequently where people come from, one of the easy way to understand is, say the European team said, I have this, want to file this patent application in the US, okay? And invariably, because inventorship is not an issue for European inventors, I have to actually tell them, well, it's wonderful that you are wanting to file this in the States, but I'm going to have to send you an entirely new data package or signature package to determine whether you're an inventor in the States based on our patent rights. And that means you have to sign a declaration, a power of attorney, and probably even a small entity statement to say that you haven't assigned this as an individual, you haven't assigned this to some other company or to some other party. And number three, the declaration of the inventorship in the States. And if they can sign all three of those and an assignment to the company, then you're good to go in the US, okay? I would do that exercise first and make sure that it's clear that they are inventors and you're not going to stumble through the US side of things, okay? On the European side, what I would suggest is, I would suggest maybe you don't file into the US or the Europe first. Maybe you file into the Patent Cooperation Treaty first, and then file simultaneously or concurrently into the US and to Europe at the same time, after you've solved all the problems and you've gotten down the road 18 months. But I think that I lean to filing the US case because first, the requirements are stiffer in the United States than in Europe to file an application. And I think that the human contribution element is stiffer barrier to meet. And once you've met those barriers, then I file into the US, then I file into the Patent Cooperation Treaty, and then file into Europe after that. Again, if I file a PCT application and I have European inventors, I might ask, instead of having the international search report done by the US receiving office, I would have it done by the European receiving office. Why? Because if I get a search done by the European office, I've met their requirements in terms of both inventorship, but also in terms of whether it meets the European standards of invention, which are novelty and different than the US. They have inventive step and not obviousness. So, and also if the search is done by the European side and I get a favorable international search report, then I can file into Europe and I will not get an extended European search report done separately by a European examiner to deal with. It'll go directly into examination. And if the European search was clear, you should be able to get a granted patent on an expedited basis. So I do both of them concurrently. Does that answer the question? Or the parts that I missed, Ravi?
I think that answered it. And then kind of the last question is, can you use AI to clean up the grammar during the description of the innovation?
Yes. The answer is yes. Yes, and I'm going to just extend that just a bit. So yeah, I mean, why not? You know, what this is a little bit about politics too, all right? All right. So are we cleaning up your pro se application and offending only yourself by the AI generated corrections? Or are you AI correcting your attorney? Okay. If you are sent a patent application by an attorney, and then you have AI correct your attorney, I think you're going to find that it creates a little bit of tension in doing that. Okay. It would become really good. It would be a bad communication to your attorney to say, oh, and by the way, I took your patent application and Chat AI doesn't like it very much. The problem with that is that what is Chat AI comparing that application to come to that sort of damning position, you know? AI doesn't have the ability to understand you as an inventor personally, your business objectives, the knowledge that that attorney has in prosecuting applications that are similar, and what your objectives are in terms of revenue generation and your strategy and claim preparation. Is it a narrow claim? Is it a broad claim? How does AI know that? So I think you have to be cautious about that in the sense that it can be very off-putting. And especially if you start using it against your attorney in a way that is counterproductive, you're going to carry on that bad impression with your attorney for years to come and through the examination of that application as well. Okay. Secondly, if AI then does an assessment and then comes up with 100 patents in the background, I will tell you that that is very harmful. Okay. First off, it means that you now know of all that patent, those patent particulars in terms of the prior art. And under Rule 56 of the CFR, you have to tell the attorney, or if you're doing pro se work, you have to tell the examiner about every one of those and provide a legible copy. Okay. I'm not sure, and it's costly to do that. I mean, to produce an information disclosure statement that has, say, 100 references is very complicated. And it is well known that AI actually hallucinates quite often and comes up with citations that aren't even real. Okay, so now you've got this problem about, is the AI actually really just cleaning up this application? Or is this AI hallucinating and giving you references that don't even exist? So that means not only are you cleaning it up, but now you've off-putted your attorney, and the attorney probably has to look at every one of those references and ask, is this a real reference? Is it real content? What do I, and make that, make that assessment as well. It adds very significantly to the cost, okay? And in litigation, this does actually come up where I had a client actually said, well, I'm going to help you with the litigation I've got chat. Chat will help me find out what the basis of a contract dispute are. And so that party sent us Chat GPT's impression of what makes a claim for breach of contract. Okay. And so it went on for pages and pages, citing a lot of recitations that are not valuable because first, we don't know if they're real citations, and secondly, are those citations actually to any cases that are falling within the jurisdiction in the law that we're actually going to prosecute the litigation? And secondly, almost invariably, chat brings back very general content. It's not at all helpful for the litigating attorney. So a bit more than you asked for, but yeah, if it's just grammar and typos, sure, we love that. Because I'll be honest with you, by the time an attorney's read I just wrote a 124-page description, I'm going to glaze over the second time that I read that. So yeah, if any impression that helps correct typographical errors or grammar is helpful.
Well, thank you, Craig. I appreciate you taking the time to give this lecture. Thank you, everyone, for coming. And I will be sure to send out the video recordings and the slide deck. So thank you all.
Thank you, Ravi. Thank you, everybody, for attending. Appreciate the attendance, and it's really my pleasure. Please feel free to call me at the firm. You know, if you call me, I'm not going to charge you. You're going to get, if you want to work with us, you're going to get some hours of free time just to make sure that we have found the inventor and the conception and the reduction to practice. Okay? Thanks, Ravi. Thank you, everybody.